Good morning, ladies and gentlemen of the Fourth Estate. Karibu to our Kenya offices. Standing before you here today, to my left is Mr. Contempt Olekina, a member of the People's Assembly Organizing Committee. To my right is Dr. David Ndi, also a member of the People's Assembly's Organizing Committee. And I am Dr. Noah Kala, the head of the Secretariat for the People's Assembly. We have a press statement we would like to make that we're going to read in parts. I will begin. Which way, Kenya? The People's Roadmap to Electoral Justice and a Just Government. First, we wish to thank the thousands of Kenyans who came to Uhuru Park on January 30th to swear in the People's President, His Excellency Raila Amolo Odinga, as the People's President. This was despite threats and intimidation by the Jubilee regime and the police. That a record number of people turned up from all corners of the country is a testament to the determination of the people to pursue electoral justice in a dignified and legitimate political struggle. We should point out that the event was as peaceful as could be, bearing testimony to what we have said and many Kenyans have known for decades. The police are the instigators of violence in our political gatherings. They are solely responsible individually and collectively for all the deaths and injuries that they have inflicted on Kenyans whose only crime is to exercise their constitutionally guaranteed political rights. May the victims' spirits torment the killers for eternity. We wish to reiterate that the swearing-in event was a response to electoral fraud. The IEBC, at the behest of Jubilee, defied the Supreme Court and failed to conduct a free, fair, and credible election. Instead, the IEBC organized a coronation ritual for Uhuru Kenyatta, boycotted by over 2/3 of Kenyans who voted on August the 8th. To date, the IEBC remains in contempt of court by refusing to open their servers. On Friday, the 26th of January, we released the results extracted from the IEBC servers showing that Raila Odinga won the August 8th election. We have challenged the IEBC on multiple occasions to open the servers to prove otherwise, by opening the servers to public independent scrutiny. They have not done so. We have all along maintained that the end game of Uhuru Kenyatta's power grab is to restore an authoritarian state. This is now reality. Political persecution through arbitrary arrests and trumped-up charges are back. The media shutdown needs no belaboring. A Kenyan citizen by birth has been deported after being detained in defiance of court orders for days. The government is defying court orders with impunity.
Ladies and gentlemen, we were promised a more lethal, brutal, and ruthless Kenyatta. He is here, but he is only living in a fool's paradise. John Adams, the second President of the United States, observed that the contention that people are the best defenders of their liberty runs into practical difficulty of assembling the masses in one place. The framers of our Constitution saw it fit to devote the first article to this challenge, providing for the people to exercise their sovereignty directly or by delegating it to only democratically elected representatives. The Constitution leaves citizens free to decide how to exercise sovereignty directly. Our answer to this is the People's Assembly. We have over the last 2 months facilitated regional People's Assemblies at the coast, which was by the Pwani Nation, Western, Luhya Nation, Lower Eastern, the Kamba Nation, and Nyanza, the Luo Nation. We are completing this in a few weeks, following which we will convene the inaugural National Convention towards the end of this month. While the immediate agenda of the People's Assembly is to secure electoral justice, we recognize that electoral fraud is a means to an end. The end is domination and exploitation of the many by the few. It is the end for which the colonial state was established and the reason why its beneficiaries are aspiring potentates kills for power. After half a century of tinkering and panel beating this edifice, we have come to the conclusion that it is not serviceable. The speed with which we can see descent into repression is testament that the authoritarian DNA of the colonial state is still intact. To secure justice and freedom, we must reimagine our nation anew, deconstruct this colonial edifice and build a new humane, people-centered government founded on our African cultural values and norms. For we believe, and know it to be true, that every Kenyan wants to live in peace coexistence with his or her neighbor. We believe, and know it to be true, that no Kenyan wants their vote to be stolen. We believe, and know it to be true, that no Kenyan wants their child to be killed by the police. We believe, and know it to be true, that every Kenyan would wish to live in a country where their child can realistically aspire to occupy the highest office in the land, irrespective of tribe, race, religion, gender, or disability.
Thank you. So, ladies and gentlemen, broadly, the agenda for the People's Assembly Convention, which we will be convening, as has been stated, is as follows. It has three items or three pillars. One is electoral justice. Under electoral justice, we will seek ways and means to end the culture of impunity, abuse of power, and electoral fraud. We will ensure that we can guarantee people the right to vote, that everyone has a right and is able to vote without being disenfranchised by being denied IDs and all sorts of things, and ensuring that every vote counts. Every vote is counted and every vote counts. We will defend the separation of powers, the independence of the judiciary, and supremacy of parliament. These are the tenets of democratic constitutions, and this, as we can all see, are very seriously imperiled. We are seeing a total assault on the judiciary, and we have seen attempts to muzzle parliament, and these are things, as we have stated, we will resist dictatorship and defend our democracy. Number two, we will be seeking to restructure the state. And in this, we will debate and resolve whether to share executive authority between the President and Prime Minister, as we had proposed under the Bomas draft constitution, or indeed to adopt a full parliamentary system as we had in the Independence Constitution and as has been maintained by most Commonwealth countries, which are former British colonies. And if you go and look at the evidence, you will see that the Commonwealth countries which maintained parliamentary systems have actually been more stable than those which adopted the kind of presidential system that we have. We will debate and decide whether executive authority should rotate between the different regions of the country, as has been proposed on occasion. And as we have stated, we are reorganizing our conversation as a conversation between the peoples of Kenya. That is why our regional platforms have been based on the various communities. So we will be convening as the peoples of Kenya and deciding how we shall be sharing power and how we shall exercise it responsibly. We shall look at how to make parliament inclusive, and especially for women and minorities. The issue of the one-third gender rule has been outstanding since 2013, and we are determined to ensure that we bring that issue into resolution. We shall address ourselves to the transformation of the security services to ensure that we transform the security services from killers to protectors of the people. Number 3, we shall be looking to strengthening and defending devolution. In this regard, we shall be looking at the proposal to establish strong political and economically viable units at the regional level as envisaged in the Bournemouth Draft Constitution. Those of you familiar with the Bournemouth Draft Constitution will know that it had proposed to have 14 regions, but in the compromise that was reached into Naivasha, we settled only for 47 counties. But we should be looking how we can bring devolution so that the devolved units can be individually and collectively, economically and strong and politically strong enough to constitute an effective check on the executive. Thank you very much, Bwana Idi. Karibu. We shall also be looking at the possibility of devolving taxation in the spirit of strengthening devolution, as well as equitable sharing of national borrowings. At this point, we have seen the crowding out of the counties by the national government borrowing overseas and using that money exclusively at the national level, and we shall be looking at how to remedy that, because the responsibility for paying that debt is shared nationally, yet only the national government is using the money. We shall also be debating the conditions, the terms, and processes by which regions can pursue self-determination. And this, as you may be aware, in the process of regional assembly platforms, the Coast has stated in its resolution that it is going to pursue the agenda of self-determination in this national convention. As we have stated already, we plan to convene the inaugural National Convention at the end of February. We will take the resolutions of the National Convention to be validated by the people by dint of a referendum and other constitutionally provided for processes. And our goal is to see the People's Assembly process culminate in a presidential election and a new electoral regime no later than August 2018. In addition to deliberating on the agenda outlined above, the convention will also inaugurate the national leadership that will support the people's president in this most solemn of national duties. In this regard, we wish to comment on a question that continues to baffle many people. How will the people's president govern without the state apparatus? Where is his seat of power? We are being asked these questions every day. We wish to point out that before the Europeans came, we lived, governed ourselves, and flourished without the structures, trappings of power, and symbols that now dominate our imagination of government. Government is not these things. Government is the will of the people. On January 30th, the people spoke. The rest is detail. Thank you very much. We will now be ready to take a few questions.
So you'll say your name, which media house you're from, and then you ask your question, please.
What are the regions that you are going to the assembly before the nomination of the national convention? And if that is set for us to witness, then you're going before the number of February.
Do you want me to take that or do I take that? Let me take that.
Just take the next one. Just say the next one.
They are still pending regional assemblies for the Ma Nation, which is due to be held in Suswa, in Narok, from where we expect them to make the declaration and resolutions. There is still a pending assembly for the Northern Frontier districts to be held in Wajir town. There is still a pending People's Assembly for Central Kenya, for Upper Eastern to be held in Meru, and for the Rift Valley to be held in Eldoret. We'll communicate the dates at a time that is convenient. Yeah, oh, and Kisii, the Kisii Nation. That will be held in Kisii Sports Club in Kisii. My apologies. Any other question? Yes, Enoch.
Thank you. Enoch Sikole from NTV. Probably my question goes to Lee. Just in the wake of things and the NRM General Miguna was reported, probably your reaction to that, and especially the reasons that were given by the government that he had denounced his citizenship.
Thank you very much. We are not aware of reasons given. We are not even confirmed that he has been deported. I mean, we see indications, suggestions that he's been put on a flight to Canada. I believe that our Constitution says that a citizenship by birth cannot be revoked. So what we are seeing with the case of Miguna, with the case of the suspensions of our passports unlawfully, with the defiance of court orders, of various court orders, including the court order to restore your television stations, is suspension of rule of law. And the suspension of the rule of law is the ultimate crisis of a state. Yeah, a state which now does not govern by law is now governing by fiat and force. As we have emphasized here, we have stated from the outset that that was the intention of Jubilee. And that is, I think, to us, what they are doing simply confirms what we have maintained all along. Yes, can I add something?
Yeah. If indeed what they're saying that Miguna has been shipped out of this nation is true, then it's not deportation as you call it. It is exile, because Miguna is a citizen of this country by birth, and therefore, where do you deport him to? Where's his home? So this is a situation gone full circle. Exactly 30 years ago, Miguna had to run away from this country, fearing for his life. That time he went into self-exile. Now it is the state that seems determined to exile him. So it is not deportation, it is exile.
Do you feel that probably the state is playing ping-pong? Because just yesterday he was charged in court as a Kenyan.
The matter is still before court. So.
I think we have some of these matters still pending before court of law. But as Dr. Ndi has said, we seem to be in a state of lawlessness, where the rule of law has been thrown out of the window, and those who are breaking the law are the ones who purport to be enforcing the rule of law.
You saw a hand somewhere there. Your name, media house?
Nauliza swali kwamba nyinyi kama NASA labda mmechukua hatua gani kuhakikisha kwamba labda tunapata kijana baada ya yeye kupelekwa Canada, hatua ambazo mnachukua kwa sasa hivi?
Kiswahili.
Unajua sisi ni wananchi, ni raia. Jukumu la kuwachunga wananchi ni la serikali. Kama serikali imeamua kuwafukuza wananchi wa Kenya ambao ni wazaliwa hapa, na hakuna jambo sisi kama wananasa tunaweza kufanya bila kutumia sheria, kwenda kotini, kuambia mahakama, kwenda mbele ya mahakama. Lakini kama serikali tayari imekataa kutii amri za mahakama, sasa hiyo ni jukumu la Wakenya kuamua kama serikali, kama mtu ambaye aliapa kuilinda katiba ndiye ameitupilia bali katiba, mtafanyaje ninyi wananchi wa Kenya? Na ni katiba yenu. Sasa hiyo ndio jawabu tunapatiana hapa. Let me say it in English. We have a rogue regime which has captured certain sections of the state, the security services, parts of the executive, and it is using those things to overthrow the constitution. They started overthrowing the constitution immediately after the Supreme Court ruling. That is the process which is underway. So the question is, what recourse do citizens have when a rogue government usurps power and attempts to overthrow the constitution? And that is the roadmap that we are providing here, how we can constitutionally take back our country from this rogue regime.
Jana Kalonzo Musyoka ambaye ni naibu kinara wa NASA alizungumza jana na kusema kwamba yuko tayari kuapisha iwapo tu kuna ule msukosuko ambao uko katika NASA unaweza kushughulikia. Je, unakubali kwamba kuna msukosuko kati ya vyama tanzu vya NASA ambao lazima ushughulikiwe kabla apishwe kama naibu rais wa Kenya?
Sisi kama kamati ya kuandalia kongamano la wananchi, jukumu letu ni kuhakikisha ya kwamba tunakuwa na hilo kongamano. Bwana Kalonzo Musyoka ni mmojawapo wale ambao ni wakuu wa NASA. Kwa hivyo kama alikuwa na tashwishi yoyote, nafikiria kuna organ ambao ni ya wakuu wa NASA wanaweza kutatua haya matatizo katika hiyo hali. Lakini sisi kama organizing committee tunashughulikia mambo ya kongamano ya wananchi.
Hamuoni kama usemi wake utaathiri mipango yenu? Usemi aliyosema jana pamoja na haya yaliyofanyika?
No, vile alivyosema yanatatuliwa na kuna kiwango chenye haya matatizo kama yapo, kwa kuwa sisi hatujui kama yapo ama la, lakini kama yapo tunajua kuna viungo vya NASA ambavyo vitashughulikia.
Anybody else? Last question.
Okay.
My passport has been revoked, and I believe we are suspended. Our information is that, in fact, all of us here, and another 10 people, I think 14 passports have been suspended illegally, I might add. But if you look at our program, you will notice we are going to be very busy. So many of us had no intentions of traveling anywhere. In the period between now and when that matter is resolved, because it cannot stand the test of constitutionality and legality. But in the meantime, we are proceeding. I think it is evidence of a level of desperation that the only thing that a sitting government can do is frivolous things, like suspending people's constitutional rights in actually fake suspension, because as far as we are aware, the administrative process that is supposed to be done before you suspend a passport has not taken place. So this is a fairly superficial political action.
And maybe maybe they should also try to suspend our IDs, because a passport is an ID, and the other ID, so that at least then we are stateless, we are nothing. But as long as you suspend mine, I am still a Maasai, or like, where will you take me? Niko hapa.
It's
Yeah,
diversionary.
and at least we don't need a passport to go to Sosua.
No.
For the next people's assembly.
No, all right. I
to
think that's
reclaim the power and sovereignty of the people of Kenya that vests with them.
Tumeambiwa we can enter. We've been told we can enter.
And the Minister for Interior all operate together as members of the executive. They don't operate in different areas at all. The lawyers appearing for the director this morning and was with us throughout yesterday. He knew about this order, and he must have known that certain steps were being taken to deport Mr. Miguna out of the country. However, what is before the court is not the deportation. What is before the court is that Mr. Miguna has to be produced. And in my humble submission, my Lord, you have then to press to make an order. But the Inspector General must appear before you. The Director of Criminal Investigation must also appear before you to give explanation and, if possible, to make an order that they must produce Mr. Miguna before you. There is no way you can make any other order. And my Lord, we cannot disobey the order of the court. The order of the court has to be respected, has to be honored by all of us. But I will allow my other learned friends to be able to say something also. I would start by asking my learned friend, Senator.
Thank you, my Lord. Yes. My Lord, first, I want to say that it is a tragedy that citizens can feel so helpless even when they decide to come to the court. My Lord, since Friday last week, the matter relating to the applicant has been before the courts, seeking assistance of the court in securing his liberty. And that has not been possible despite the orders that have been made by the Honorable Court. My Lord, just to emphasize what our learned friend, Senior Counsel, Dr. John Hamino, has mentioned to the court, the orders of the court were very clear. The orders of the court, first of all, in Kajiado, which were made early enough for the presentation of the applicant before this court, were made before 1 o'clock. Although it doesn't appear from the order, but it is clear from the lawyers who are representing the applicant at the proceedings Kajiado that the orders were made before 1 o'clock for the applicant to be released to this court, to be brought before this court before 3 p.m. My Lord, in the face of this order, the police had no other alternative but to deliver the applicant to this court. My Lord, there were various orders that you made yesterday, and finally the order that this court made in the evening last night, which were to be served, and indeed the Director of Public Prosecution demonstrated to the court that the respondents were made aware. That order also required that the applicant be brought before this court before 11 p.m. My Lord, what we are saying, where does a citizen go if a citizen who seeks the protection of the court cannot get it? Where are the values which are enunciated in the Constitution, Article 10? How can those values and principles be invoked, safeguarded, and implemented on behalf of the citizens? My Lord, without this court making a firm order in respect of the applications that we made yesterday against the respondents, we are going to build an environment where impunity becomes the order of the day. Now, my Lord, I was yesterday, and I think I'll look for that authority at some point and make it available to the court, where the President of South Africa was required to appear before the High Court in South Africa as a witness. And the position of the government was that the President could not appear because he enjoys immunity. And the reasoning of the court in South Africa was that South Africa is a constitutional democracy and nobody is above the law. And to enjoy immunity, you must also demonstrate that you are abiding by the law. You cannot break the law and want to enjoy the privileges that is vested in your office or in the person of any public officer. And I think the late President Mandela made the work easy by saying he will appear. So the fact that every time an order is made for a senior public officer to appear before the court and they don't appear, that is something the court cannot take for granted. It must be demonstrated that however high one's office is, once the court makes an order, it is not upon you to send the representatives, which is what the respondents have been doing. My Lord, I would probably not try to get into the province of talking about the immigration law and the right of citizens, because probably there will be another forum. But my Lord, I know as somebody who suffered from this in the old regime, where I was removed from a plane and brought back that I could not travel, or my passport taken. Section 12 of the Constitution, which refers to Article 12, yeah, that a passport or a national identity card is not a privilege. It is a right. And that read together with the fact that, citizenship by birth, I think that is Article 16. No, 14. 16. A citizen by birth does not lose citizenship. And I've looked at the papers which the learned Ms. Ondimu has produced before the court. It shows that Mr. Miguna was born in Kisumu. His place of birth was Kisumu. And therefore, all that the Cabinet Secretary has done does not find favor with the law, but probably will address the court at another occasion on that very point. But if indeed Mr. Miguna was a Canadian citizen, again, what you can see from the documents which have been supplied by the prosecution is that even the Canadian High Commission was complaining about non-compliance with the law, not only the law of this country, but with international conventions to which Kenya is a party. And therefore, my Lord, I would submit that the Inspector General, together with the Director of Criminal Investigations, should appear before you to explain, because this matter is no longer to deal with whether Mr. Miguna is here or not. But the more important question, have they complied with the orders of this court? And for that matter, my Lord, we'll still insist that the Inspector General and the Director of Criminal Investigations appear before your Lordship. And then, my Lord, there are also provisions which the Cabinet Secretary really should be familiar with. Who is a prohibited immigrant? You cannot be a prohibited immigrant if you're a citizen. The Constitution and the law does not contemplate a Kenyan by birth being declared a prohibited citizen. And the procedures for revocation of citizenship are made spelled out clearly in the Constitution and in the law relating to the immigration. And in any case, as your Lordship pointed out the other day, the fair trial as a right is non-derogable. So Mr. Miguna should have been given an opportunity on the basis of the allegations that were being made for him to put his case so the court could make a determination as to whether or not what the prosecution is saying is true or not, and whether those orders were indeed justifiable. But I just want to finish by saying, my Lord, these courts are the protector of citizens and their rights. Once we cannot find safety and protection from the courts, we are opening the state to anarchy, and accountability and respect of the law will lose its mandatory requirements. It is in the 16th century, I think, or 15th, when Louis XIV said, "L'État, c'est moi, I am the state." Nobody can't be the state. The people of Kenya are the state, and all powers are delegated to various institutions of government. We can easily get there if the courts do not come in firmly and deal with errant public officers. So, my Lord, again, let the Inspector General appear before you. Let the Director of Criminal Investigations appear before you and give full account why they took the action that they took, delivering somebody who was a ward of the court. Mr. Miguna, throughout, was a ward of the court from Kajiado, and he should have been treated in the manner in which the court had directed. Thank you.
My Lord, the second counsel is Tulak Alonso Jr., Senator.
Yes, Thank you, my Lord. My Lord, the position taken by the prosecutor that at some point between the time they released Mr. Miguna, the applicant, he was taken by the immigration, is nothing but a falsehood. It's a lie. It quacks like a duck. It is a duck, and my Lord must find it to be a duck. Because, my Lord, you granted anticipatory bail. That means Miguna was under your custody until delivered to you. The circumstances under which Miguna ends up with the immigration, who are part of the police and part of government, is something, my Lord, must be tested by you. On the contempt, because, my Lord, after you granted the order and they violated, the contempt of court proceedings are alive until purged. Purged to the extent, my lord, that there must be an explanation as to the reason why a court in Kajiado released Mr. Miguna, and at some point he ended up in a plane on his way to Amsterdam. The public prosecutor should be extremely embarrassed that he has given you a ticket using taxpayers' money, that Miguna has been transported to some place because he's not a Kenyan citizen. That process, my lord, is quasi-judicial. That process, at arriving at the conclusion of what they have given you today, that Mr. Miguna is not a Kenyan citizen, is a quasi-judicial proceeding. My lord, before the contempt is purged, you must see that process. Who made that decision? When was it made? Who sat in that meeting? And where are the minutes? That's the law. But more importantly, my lord, I'm glad that I'm appearing before you today, because in 2008, a similar case like this one, Mr. Mohamed Sirat, who appeared before you as a petitioner, was deported by the Kenyan government in the middle of a petition. My lord, you stopped that petition, determined that the deportation was an attempt to circumvent that petition. And my lord, that gentleman ended up being an MP, sitting in parliament. Kenyan government had declared him persona non grata. That case is not any different from what has happened to Miguna. And why is that so? Mr. Miguna, my lord, was cleared to contest as a governor in Nairobi under Article 99. Mr. Miguna would not have been a voter if he was not a citizen. When did they realize he's not a citizen? All these things, my lord, is part of the contempt, is part of finding a way to circumvent appearing before. My lord, you should not allow that to happen. Before they come, stand there on oath and tell you, my lord, how they ended up circumventing your order. Because the process of deporting any person, whether it's a Kenyan or non-citizen, is also part of the Kenyan law, and that person must appear before the court. That is what the Constitution says. And therefore, my lord, if there's ever been a definition of travesty of justice, today and yesterday is where that definition fits squarely. If there's ever been a scurrilous abuse of court process, my lord, this is one instance. And if we cannot put an end to this, if we cannot dot the I's and cross the T's about violation of the principles under the fundamental rights, my lord, we might as well pack the Constitution of Kenya in a shelf and start using scrolls or something. But as long as, my lord, you're sitting here, take an oath to protect the Constitution, whether Miguna is in Amsterdam, whether Miguna is in Montreal, whether Miguna is under the sea, my lord, you can issue an order. That is our position. Because his fundamental rights have been violated, whether under the sea or anywhere else, my lord. So therefore, they must appear before you to show cause. And if they don't show cause, my lord, you can issue an order, my lord, for an explanation and to bring back Miguna back to the country. But before that, my lord, please summon them again to come before you. Thank you.
My Lord, I'll be very brief. My Lord, this is a clear case where the respondents are abusing not only the administrative power, but also judicial power. My Lord, I say this because this debacle commenced with the court order that was issued by the Chief Magistrate on the 1st of February 2018. It is on the basis of that order that the respondents proceeded to the house of Miguna, blew the entire gate, blew the entire front door, and seized him. Now, when this action was being undertaken, it was being undertaken on the suspicion by the police that Miguna was keeping weapons in his house, and he was also keeping documents that are intended to subvert the course of justice,
and to undermine the authority of the government of the Republic of Kenya. My Lord, there has been no return filed in those miscellaneous proceedings to indicate what, if any, the police recovered from that raid. My Lord, fast forward until yesterday, Miguna was in the custody of the court. It cannot lie in the mouth of the respondents to say that at one point in time they lost custody of Miguna. Because, my Lord, you remember all of us waited here until yesterday at about 7 p.m. and all indicators were that he was in the custody of the police. Yet, in actual fact, if you are to look at these documents now presented, it will appear that the court was being kept here in waiting as another parallel process was being undertaken, quote in quote, to deport Miguna. My Lord, as my learned senior has indicated, we'll interrogate the so-called deportation at another forum. But the documents that have been produced by my learned colleague from the DPP confirm that Miguna holds a Kenyan passport. So, my Lord, to that extent and that extent only, Miguna still remains a subject matter of these proceedings. It is therefore my humble submission, as has been said by my colleagues, that over and above demanding the personal presence of the IG and the DCI, they still have to produce Miguna, because Miguna is still the subject matter of this court.
Yes. Well, my next answer is Mr. Senator Mutula Kilonzo Jr. Yes. Okay. Sorry, this one better. Yeah, I'm sorry. Yeah, it is.
My Lord, standing here this morning, inasmuch as this matter is always about the rights of the person that we are representing, doesn't it make us a bit apprehensive that orders are not being followed anymore? And if they're not being followed anymore, and you have given this order, and this being the fourth order, isn't this egg being thrown in your face? Aren't we getting splattered? Do we then feel comfortable that we can come to court and ask for orders? And if then the orders are not followed, then why, the question is, why do we come? And my Lord, the police in this matter, and I must just say this, and without any fear, without embarrassment, they are testing you. They want to see what kind of limit you can reach. Because if you tell them, please appear before me, they don't do that, what goes in their mind? They must be discussing and saying, ula anatuita tu, tuskaende, atafanya nini? And then when nothing happens, they will come back again and say, anatuita tu, weenda, somebody else is sent. My Lord, this is when you need to show your teeth. Please bite somebody. Bite somebody and bite very hard. Don't let go. You must spill blood. Somebody that must is good. You have shown your teeth. and when I say bite somebody, at least you have got two people that you call who are supposed to appear today. Two of them, and they have sent somebody else. If that person is in court here today, start with that one. That is the one you bite first. Because he must be able, when he comes to court, to also take the consequences. Let him not come here and come and tell you later on, watch niende nimwambie. Because when they go back there, they sit in a conference and laugh and think, what do we do next? That is not what they need to do. They need to say, first of all, this is an order. Let us obey and see what comes next. My Lord, I do not want to be embarrassed to be a lawyer today. But isn't it embarrassing? My Lord, bite. That is what I'm asking you to do. Please bite very hard. Use the molars, incisors, the canines, but bite. That is what I'm asking.
Yes, my Lord. The law society of Kenya is deeply concerned at the height of impunity being shown and demonstrated to the court by the respondents in terms of suggesting that the court means nothing to them. You have, perhaps before I go to the orders that you have given, remember that these respondents, the police, used the court to obtain legal authority to commit crime. They went to the subordinate court under a miscellaneous application, got an order for entry and break-in. Actually, it was to gain access and search, but they went to destroy property. Like my last colleague, Mr. Javier said, they have not returned that warrant to the court to explain to the court what they did and whether they arrested anyone. Then they came to, the applicant came to court and obtained bail and even paid for it. The police refused to obey that order. You subsequently ordered them to come. 2-3 times they have failed to come. What they are showing you, my lord, is not disrespect to Miguna. They are not slighting Miguna. They are slighting you. They are slighting the judiciary as a whole. I do recall, my lord, not too long ago, when politicians in the highest echelons of society were attacking the judiciary viciously, the Chief Justice, His Lordship Maraga, suggested in a public statement that if they don't like the judiciary, amend the Constitution and scrap it. They have chosen the easier way. They don't want to amend the Constitution, but they are scrapping the judiciary in terms of disobeying orders that are issued by the judiciary. More important, orders made by the court. I join colleagues in saying the contempt has to be purged by all the officers you named and go at a later stage in probably different proceedings. We would like to see Mr. or Dr. Matiang'i has signed off as Fred Matiang'i, PhD, EGH, Cabinet Secretary. We will be dealing with him to show him that he doesn't even have power to sign the document he has signed, because in the government he's serving, he has not been sworn as a Cabinet Secretary for Interior. So he has no power that he's pretending to. If you look at the section he is citing, that was cited by my friend Duncan Ondimu, Section 33 deals with prohibited immigrants. There is a process to having a person declared as a prohibited immigrant. Section 43 gives the Cabinet Secretary power to make these orders upon recommendation from some authority or a tribunal. It can't be that they investigated yesterday on 6th, they took Miguna's papers to him, and then he signs. There is a tribunal that ought to have been the subject of some proceeding, which he will be telling us at that stage. So, my lord, the illegalities that have been committed are undermining the authority of this court and telling us the rule of law means nothing except when you are in government. We must stop them in their tracks. I join Mr. Umbeta in saying bite really hard. Yesterday, I suggested the same thing, that the representatives who came to court ought to have been detained until Mr. Boynet and Mr. Kinoti came to court with Miguna. It is even shameful, my lord, that they would lie to you personally. Remember, before we were adjourned after your ruling in the afternoon, you said you had been assured Mr. Miguna is in court and will be released. That's...
He was actually in court. He was not in court.
You see, it is so shameful that they can taunt you in your face and say, we'll dangle Mr. Miguna here to assuage them, give them some palliative care, and then we can do what we want to do. I'm embarrassed that Mr. Ondimu, counsel whom I deeply respect, can take instructions of falsehoods and be sent here to present, to be a messenger.
I think, my lord, I think my colleague, I have not, none of the senior colleagues here has gone into my person. All advocates here act on instructions. If those are my instructions, let him reply to my instructions. Not saying that he's embarrassed going in. I'm an advocate just like he is. I've worked with him in private sector and he knows where I am. So he can't purport to know what instructions I receive. So let him stick to his instructions.
Yes. Thank you.
Mr. Nubli, I know you want a life.
Yes.
So stick to
my instructions. Yes. I will buy him tea when we leave. But the point I'm making, perhaps if I refer to his clients, to provide false information, false instructions to counsel, when as counsel, even on our side, we have sworn to defend the truth and defend the law and justice. It is also contemptuous of them to counsel, to give him lies, to present those lies to you. So they are in contempt of the lawyer, they are in contempt of the court, and they are in contempt of us on the other side as lawyers. They are in contempt of the applicant in terms of providing starkly false information to the court. But this long and short of what I'm saying, my lord, is the persons you named must come to court in person, purge their contempt. And part of the things they must do to purge their contempt is to present Mr. Miguna to you before in court in Nairobi, Milimani. Not to ask you to go to Ottawa or elsewhere to go and look at him. They must bring him here. If they purport to uphold the law, they must know that court orders are the law. Thank you very much.
My Lord, I have a very brief reply. My Lord, yesterday there were two orders that the court made. The first ruling which was delivered. The first ruling which was delivered was to the effect that there was no need for the DCI and the IG to appear before court.
That was good.
Yeah. The second order, the effect that the DCI director and Mr. Saidi do appear before court. So it is not true that the IG was required to appear pursuant to the second ruling. The people who were required to appear today were the DCI and Mr. Saidi, the officer in charge of flying school. As I have indicated, the predicament that is facing the DCI and where he is currently, it would have been impossible for him yesterday to make the arrangement because we all know what's going on in Boni Forest and they need to address that issue. My Lord, you've been referred to by my senior colleague to the various orders that the Chief Magistrate's Court in Kajiado in Kia made. My Lord, if my colleagues have a problem with the search warrant and whether the returns have been made, the best forum would be at the Chief Magistrate Court to question whether the respective returns have been made and how that search warrant was executed. In regard to the orders that were made by the Kajiado Court, the Kajiado Court, yes, made certain orders. As to whether those orders have been obeyed, this, in my humble view, would not be the appropriate forum to address those particular issues. In respect to the issues that have been referred to the case of Mr. Siraj, I somehow handled part of the prosecution. The petition that he filed at High Court in regard to challenging the decision of the Immigration Department was actually dismissed. Mr. Siraj, through his advocate, my senior colleague, filed the notice of appeal.
The petition was allowed.
No, not the election petition. There was another petition.
The petition was allowed by Justice George Lee. The petition was allowed. That's why I proceeded with the election petition.
There was certain...
That is correct, my lord.
That is not correct. There is a notice of appeal that was filed by him. Why would he be filing a notice of appeal at the Court of Appeal? And he was granted stay orders against a criminal prosecution in Milimani Court.
It was a criminal prosecution, but the JR proceedings were heard by Justice Lee were allowed. And the decision of the Director of Immigration was quashed.
My Lord,
and I have that judgment.
Thank you for
I
the
also
assistance.
have two contrary judgments. My Lord, in that regard, I have two contrary judgments in that.
And it doesn't believe you.
You can adjourn this court and go and get those decisions.
Yes. Yeah. My Lord, I do have contrary decisions which I'll be relying on in my submission. I never thought this issue would arise, but I came prepared for such an issue to arise.
But you leave a report of this. But it's a good admission.
Proceed with your response. You know your response is now. Those authorities will not cite them. Just respond.
The two decisions, they've questioned the basis under which the immigration made the deportation
You
order.
have said that issue will be addressed at another forum.
Correct.
You are supposed to address the issue of why the orders of this court were not complied with.
My Lord, the orders of this court have not been disobeyed. It's a humble submission. No order. You've been told that you need to. The orders, one of the things is that the orders were complied with. The orders were directed to the DCI and OC Flying Squad to release Mr. Miguna. If another government department, which the DCI and Mr. Saidi do not control, take possession of this individual, you cannot blame Mr. Saidi and the DCI. The only application should be, what basis did the immigration department take up this individual? If this court issues an order for the immigration department to come and explain what was the basis for them taking up Mr. Miguna, would gladly then take up that matter and serve the immigration department on behalf of this court. But it's not the two individuals who had been directed to produce Mr. Miguna disobeyed the court. It is not that the two agents of the government have any disrespect, or anyone within the circle have any disrespect towards the court, towards the judiciary, and there is no need for this court to bite. We know courts can bite.
The question you asked is, was he produced before this court?
Yes. I have no knowledge. He was required to be produced. I never saw him. I heard in court.
He was not produced. He was not physically produced before this court. At what point did the immigration department assume his custody? From who?
The custody was assumed from the officers acting under Mr. Saidi. They were picked by immigration.
The custody was taken from officers under Mr. Saidi, who is under the DCI, who was acting under instruction of the DCI. Is that, just talk so that I can hear you. Don't shake your head, I'm just saying for the record, just say the instructions were given by Mr. Saidi so that he handed over the custody of the applicant to the immigration officer without passing through this court's custody.
My Lord, the orders that court issued the first ruling, the court said, and even when the ruling was delivered at faith, the court said that either way Mr. Miguna should be released, not necessarily brought before this court. That's what I got the ruling to mean.
But did the court indicate that it was going to wait, even if it was late, to receive Mr. Miguna so that he can release him?
I was present in court, and I actually waited in court.
You waited? You waited until 7 o'clock with us. It's not you did. You didn't wait with us up to 7 p.m.
And that's when I learned of all this, what was going on after I
and your
left.
instructions to court, your submissions which are on record, is that you have no instructions. You are saying that the people are not communicating with you.
Yeah, in fact, switched off their phones.
They had switched off, even Mr. Saidi had switched on his phone.
Switched off.
It's on record.
I remember what I said. But all this I learned after I had left court late at night.
Okay, I've had you. You can conclude your submission.
My Lord, you've been asked to crucify the officer who had been sent by the DCI. The officer came and was sent by the DCI out of respect to this court, not to show that he disobeyed the court. This is merely a messenger. You do not crucify a messenger. You don't crucify a messenger. You don't bite a messenger. You receive the message and evaluate that message. That would be all. And there will be no need to bite anymore.
May I say something?
Maybe just one last point I forgot to mention in respect to the fact that the subject matter, the applicant is already out of jurisdiction, and whether court can make any subsequent orders. I wish to refer to the case of Zuhura Suleiman.
I'm not receiving any authorities.
Most of
You are supposed to accept those authorities.
No, it's because the issues, I never thought they would respond. And since it's a legal issue that arose during reply, then I would only have cases to reply legally on this issue.
That is incorrect, my lord, because he's the one who rose this issue, who brought these issues.
What's the name of the Director of Immigration? Kialangwa.
Major General Retired Gordon O. Kalonzo, that is KHALANGWA.
My Lord, I have a letter he wrote to me which gives his full name and title.
Don't know where the reports are.
Okay, this is my ruling. From the submissions made, it is clear to this court that there is an obvious contempt of the orders of this court and a deliberate attempt by state agencies to subvert the rule of law in this country. Court orders, once issued, must be obeyed. For the court to make an appropriate determination on what course of action to take, it hereby directs the second and third respondents in person to swear affidavits in regard to the circumstances under which the applicant was released from their custody to the Directorate of Immigration during the subsistence of a valid court order requiring them to produce the applicant before this court so that he can be dealt with in accordance with the law. The Director of Immigration, Major General Gordon Kihalangwa, must swear an affidavit to indicate under what circumstances he assumed custody of the applicant when he knew that he was under the custody of the court awaiting his release. The affidavits must be filed and served by Friday, the 9th February 2018. The applicant and the interested party have a right, must be filed and served. The applicant and the interested party, that is the Law Society of Kenya, have a right to file affidavits in response to the affidavits that shall be filed. Further, the second respondent, Mr. George Kinoti, and the third respondent, Mr. Joseph Boynet, must further swear affidavits to show cause why they should not be punished in accordance with the Contempt of Court Act for disobeying the orders of this court. They shall be required to appear in person before this court on 14th February 2018 at 9 a.m. to show cause. Thereafter, these proceedings are adjourned to that date. It is so ordered. 9 a.m.
Yes. I wish to request on 14th I do have a matter of court of appeal. I was requesting if it could come on 13th or 15th.
15th.
Briefly appreciate 15th.
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 Yes. Thank you very much.